the bank to bring any, we did not subpoena the BSP and say any bank account of Justice Corona. There was certain bank account numbers given by this court. Number two, while the doctrine of the poisonous, the fruit of the poisonous fruit is clear, and all lawyers will know that when it comes to illegal searches, sa subpoena po, ang lumalabas po, di ba, pag may exclusionary rule, ibig sabihin nakalagay sa batas na yon, any evidence obtained through this cannot be used in court, de malinaw na hindi pwedeng gamitin. Pero pag walang exclusionary rule, ibig sabihin, pwede pa rin gamitin. Halimbawa po, or at least question mark, and I'll allow you to explain if your view is that even without an exclusionary rule, pwedeng gamitin. Halimbawa po sa bank accounts, no? Ang nakalagay doon, paparusahan lang ang taga-bangko na naglabas nun. Pero walang nakalagay doon sa batas na yun na hindi pwedeng gamitin. Kaya yung testimony ni Clarissa Ocampo ay ginamit. Or to use a more example na mas alam ng ating kababayan, si Senator Lacson po, nung lumapit sa kanya si Mr. Udong Mahusay, may dala ho siyang bulto ng dokumento, may mga bank accounts allegedly ni First Gentleman at ni Jose Pidal. No? Kung ano-ano nakalagay doon, Morgan Stanley, sa mga bangko, may mga iba pang hindi nilabas si Senator Lacson dahil tingin niya compromising yon. Yung po, theoretically, ay nakaw ni Udong allegedly kay First Gentleman. Bakit? Hindi naman sa kanya yon. Pero hindi siya illegal search dahil hindi naman gobyerno at hindi naman po mga taga-NBI o police ang kumuha. So, yung po ba ay, I'm not asking this specific case, no, but just so that we can understand and I can understand. Ang pagkaintindi ko po, walang exclusionary rule yon. May violation of the bank secrecy law dahil yung isang katiwala ni First Gentleman ay naglabas ng dokumento na hindi sa kanya at ninakaw niya yon. Pero hindi naman illegal search. Hindi naman Chief PNP si Senator Lacson nung panahon na yon at lumapit sa kanya. So, sir, when you make the memo of law, I get what you're driving at. But can you help us by showing us that fine line? When is a subpoena legitimate? And when do you think a subpoena will now become illegal or unreasonable search, giving us the logical conclusion that it will fall under the doctrine of the fruit of the poisonous tree? Or where is a subpoena either legitimate or when is a subpoena defective but it does not affect the admissibility of the evidence? As to relevance and materiality, I hear where you're coming from. Ibang issue yon. I'm just talking about the exclusionary rule, the rule of whether evidence can be accepted or not. So I think this is something that both parties have to clarify on that issue. Saan po ang thin line at saan po nagkakaiba ang subpoena at ang search warrant po or an unreasonable search? Thank you, Mr. President.
Mr. President,
there being a request from a member of the court for the submission of memorandum to clarify this issue, it is the mind of this presiding officer to request both parties to submit the respective memorandum on this specific issue, not only for the information of the public, but for the guidance of this court as well. And this presiding officer will make a statement after everybody has spoken.
If Your Honor,
Mr.
please,
President.
very willingly we will comply, Your Honor.
May I just let the defense counsel first to finish?
Very willingly, Your Honor, we will comply. But may we request that we be given at least 5 days, Your Honor, in view of the importance of the issue involved, Your Honor.
Granted.
Thank you, Your Honor.
Granted.
May we ask for the same period as well, Mr. President?
Granted.
Mr.
Thank
President.
you, sir.
The gentleman from Pampanga.
Yes, on the issue of the memorandum, if you may also consider explaining to this court why you would consider subpoena or a subpoena of this court in the same category as a warrant of arrest or a search warrant. Please.
Yeah,
so that
definitely we will.
Thank you.
Definitely we will.
Yes, sir.
Mr. President, may we recognize Miriam Defensor Santiago on another issue.
This is a legal manifestation addressed to both panels. Gentlemen, you
The
may
gentle lady from Iloilo is recognized.
Thank you. Gentlemen, you may take your seats. In the first place, I don't understand why we are discussing a search warrant. This court has not issued a search warrant. What search warrant are we talking about? What we issued was a subpoena. Therefore, the issue should be, what are the effects of the subpoena, considering that when the subpoena was requested for by prosecution, it attached what purported to be bank documents, but immediately the prosecution disavowed any knowledge of the authenticity of the document. Therefore, the issue is, can counsel in any proceeding attach to his request for subpoena a document about which he knows nothing? That's the issue. Hindi mo pala alam kung ano yun eh. Bakit mo sisingilin kami na issue kami ng subpoena? Eh ano yun? That's only a scrap of paper. Why are you doing this to the court? Why didn't you go hit your law books? So, kung ano-ano mga pinagsasabihin nyo ah. Hindi naman ito kursunada eh. Siguro ito sa jurisprudence. Dito sa inyong supplemental request for subpoena/reply dated February 3, paragraph 11. I will start even earlier. Paragraph 10. Recently, an anonymous source provided the prosecution with photocopies of what appears to be PS Bank documents without more. Pwede na ba yun sa korte? An anonymous source told us. So we're alleging it in our request for subpoena. Is that allowed? Can you allege something in open court or even in a written pleading with a court that you have information, but it is based on an anonymous source? My goodness, if you bring this to any trial judge in the entire country, particularly in Metro Manila, you'll be cited for contempt. I know that I said that impeachment is quasi-judicial and quasi-political, but you cannot tamper with the rules of court which are suppletorily applicable to our rules of the Senate on impeachment. Saan ka nakakita ng pleading na somebody anonymous said like this to us, so we're going to ask the court to do something? What kind of respect for the Supreme Court are you entertaining in your minds? Pangalawa, basahin ko sa inyo, this is a very, very strange, bizarre document. Imagine telling me if I were a trial judge, an anonymous source told me, Your Honor, that something happened, so will you please issue a subpoena? Can that be a basis for issuance of subpoena? Paragraph 11. Moreover, it seems that the media itself also has information. Kailan naman ng judge pwede mong hikayatin o pwede mong pakiusapan na gumawa ng kung ano mang aksyon na gusto mo, issuance of a subpoena, on the basis of a media account? My goodness! Is this government by media or is this judicial system by media? Again, this is a ground for contempt. If I were a trial judge, I would say, you're wasting my time. Sheriff, take him to city jail. Direct contempt yun eh. Pero mo, if you're going to the court in a serious frame of mind, you are met by this kind of a pleading. May narinig kami sa isang babae na hindi namin masabi kung sino yon. May nabasa kami sa dyaryo. Opposing counsel in all trial courts of our country will go apoplectic objecting to that kind of a request. May just point that out to those people who have never been to trial court. Paragraph 12. While it cannot vouch for the authenticity of the said documents, the prosecution believed that it is its duty to submit the documents to this court as they may have a bearing on the court's resolution of the pending request for subpoena. Huh? Say again? 1, I heard someone who I cannot identify say something. Number 2, I read it in the media. Now, it is my duty to bring it to the attention of the court. Duty my foot. It is not your duty. It is your liability. That is disgrace to the judicial system. And I have basis for saying that. I will read you the case. In these cases of false or fake documents, which yesterday the bank manager asseverated, she said, that's a fake document. In the case of fake documents introduced in court, here is what the Supreme Court had to say. Based on administrative cases against certain judges, an administrative case is a case for disbarment. Ganon katindi. Pag nagbigay ka ng peke dokumento, peke na testimonya sa korte, ganon katindi yan. Pwede yung base, ipa-disbar mong abogado. There are two cases. One, where the lawyer himself did not know that the document was false, did not participate in its preparation. And the other is where the lawyer willfully introduced what he knew to be fake documents. Let's talk about the first instance. The lawyer willfully knew the document was fake. Here is what the Supreme Court said in Samala v. Valencia. I beg the indulgence of this court. I'm hyperventilating because I'm very, very upset. I will leave this court immediately because I'm sure I have hypertension. Samala v. Valencia, 512 Scra. 1. Decided in 2007. Here is what the Supreme Court said. Respondent cannot feign ignorance of the fact that the title he submitted was already cancelled. In other words, the Supreme Court is saying, we are concerned, we are aghast that the lawyer knew that the document he submitted was false. Respondent failed to comply with Canon 10 of the Code of Professional Responsibility, which provides that the lawyer shall not do any falsehood, nor consent to the doing of any in court, nor shall he mislead or allow the court to be misled by any artifice. It matters not that the trial court was not misled by respondent's submission. Notice the court said, even if that false document did not mislead the court, still the lawyer is liable. Because the burden should not be placed on the court to determine whether the document is true or not. It is the duty of the lawyer who is introducing it. It matters not that the trial court was not misled by respondent's submission. What is decisive in this case is respondent's intent in trying to mislead the court by presenting this document. That's what the Supreme Court said. If the lawyer willfully introduced fake document, the Supreme Court will condemn the lawyer. I will see what the penalty was. Accordingly, the court finds the lawyer guilty of misconduct and violation of Canons 21, 10, and 1 of the Code of Professional Responsibility. He is suspended from the practice of law for 3 years, effective immediately upon receipt of this resolution. That is a decided case. It binds us all here. But that is in the case of a lawyer who knowingly and willfully introduced a fake document. Now let us grant the presumption of innocence to the prosecution panel. Suppose they did not know, as they indeed said in their pleading, they could not vouch for the authenticity of the document. Do they still have any liability? Yes, said no other than former Chief Justice Enrique Fernando, one of the most brilliant lawyers produced by this country. Justice Fernando wrote, in the case of Berenguer v. Carranza, 26 CRA,